Thank you very much. I really appreciate being invited to your annual meeting. It's a great opportunity for me to get out of the office and actually interact with some of the people who make my job a lot more interesting. So tonight we're going to talk about easements and right-of-ways in our forests. And that's probably going to mean something a little bit different to everyone, but I hope you all come away with hopefully learning something new, or at least thinking about these issues in some different ways. So I'm the supervising attorney in the Pennsylvania office for Fair Shake Environmental Legal Services. We're a nonprofit environmental law firm. We do a lot of environmental, land use, and natural resources legal work for everyone from nonprofits to individual property owners to citizen organizations. And hopefully we'll talk a little bit about some of those cases or similar cases as we go through the presentation. And I went to law school, so I have to add one of these, but that's okay. Just to give you a quick overview of where we're going, first we're going to talk just a little bit about some of the background legal principles related to easements and right-of-ways. How are they created? What types of easements are there? And how does that impact everything that comes next? So hopefully you're going to see that those background principles play into how you deal with your existing easements, how you negotiate new easements, maybe how you terminate the easements, and everything else. So at the end of the sort of presentation, you also have an opportunity to ask questions. But first, we should talk about kind of this distinction in terminology, right? So you're going to hear me say easement probably like 100 times over the next 30 minutes, but I could almost just as easily say right-of-way. There's some technical differences between the two terms. I often think about an easement as a right to use property and a right-of-way as a right to pass through property. So you'll think about an easement like a parking easement or a conservation easement. You'll think about a right-of-way like an underground utility or an above-ground utility that's merely passing through your property. So what is an easement? The Black's Law Dictionary, which is where we look for all definitions, right, describes it in a pretty confusing way. But you should just know that generally, when you think about property principles, you may have heard this before, you can think about your property ownership as a bundle of sticks, right? And every time you give away one of those sticks, you're giving away some interest in the property. And an easement is nothing different. You're giving away some partial interest in that property while retaining your own possession of the property. And I think it's important to understand some of the sort of terminology that will also be thrown around and that you're going to see in a lot of these, or probably already have seen in these easement agreements. So in Pennsylvania, we talk about servient and dominant estates. In the context of easements, the servient estate is the land that gives the easement for the benefit of another person or land. The dominant estate is the land that obtains the benefit. I like to think about it in terms of mineral interest and surface interest in a totally different context, I guess. But in Pennsylvania, you can divide your property interests, and often the mineral estate is divided from the surface estate. And the surface estate is known as the servient estate because the mineral interest owner, unless some written agreement says otherwise, is the dominant estate and has reasonable access to the surface as needed to get those minerals. That's kind of the distinction between servient and dominant estates. There's really two different types of easements, though. There are appurtenant easements and easements in gross. And you might see this language in some of the written documents if you've reviewed easements or right-of-way agreements. So first, an appurtenant easement is an easement that benefits the owner of an adjacent property. So the way that I think about this is if my neighbor gives me an easement for my driveway, so that I can cross his property and access my property, that's an appurtenant easement. It benefits me as the property owner, but it also benefits my property in that without it, I couldn't have that driveway, I couldn't access that property. Typically, it's an adjacent property because you need to have some sort of physical access, and it's important to know that that appurtenant easement transfers with the land automatically. So even if your deed doesn't explicitly talk about that appurtenant easement, if the language of that easement says that it's appurtenant, it's going to transfer automatically with that property. On the other hand, an easement in gross does not transfer with the property because it's a personal use, a personal right in the real estate of someone else. So for an example, you might think about this like if I obtained an easement to hunt on my grandfather's property, that's a personal interest that I have in that property, even though I have no property ownership anywhere. It's merely my right to use that property for those specified purposes. And the important thing to know in that situation is that the easement in gross does not transfer with the property, right? Because it's not tied to any specific property that it benefits, but it's tied to an individual or an entity that holds that property interest. And there was a recent decision, the Keegan decision was decided by the Pennsylvania Superior Court just the end of this summer, that I think helps kind of describe why that distinction between the appurtenant easement and the easement in gross is so important, right? In 1965, Keegan purchases a property, 48 acres on a mountainside somewhere in Pennsylvania. 10 years later, a neighboring property owner, Matones, approaches him and requests an easement for ingress and egress across the property. Keegan grants that, and Matones builds a dirt road on that easement. 10 years later, Matones deeds his property to Lagana, but never mentions the easement in the deed. Lagana subdivides the property, he builds townhomes, the township paves the dirt road, and at that point, Keegan says, wait a second, I granted this easement to Matones, and now Lagana is using this to park cars, he's putting landscaping on it, they're using it for access to all of these townhomes. That has nothing to do with what I granted the easement to Matones for. So he files suit saying you need to get off my property. That was an easement in gross. It doesn't transfer with the property. And the trial court, they agreed with him. They said, that sounds right. It wasn't written into the deed, and the easement was explicitly given to Matones, not Lagana. But on appeal, the Pennsylvania Superior Court took a closer look at this. And after a lot of discussion, they actually decided that since the easement language didn't specify whether it was an easement in gross or an easement in pertinent, and because that easement was granted for the sole purpose of access to that property, they decided it was actually an easement appurtenant, meaning that it automatically transferred with the property, even though it wasn't in the deed. So, a really long-winded way of saying that it's important to know what kind of easement you're obtaining or giving up. And it's even probably more important to make that explicit in the written agreement. But when you're creating an easement, right, there's pretty much two major ways that easements can be created, either by an express written agreement, which we already talked about, or by actions. And we'll talk about the actions in a second. But first, when you're talking about creating an express agreement, there's two ways that you can create an easement. The first is by grant, and that means that I, as the property owner, grant John Smith over here an easement voluntarily, usually in exchange for some type of compensation, an easement. An easement and grant, without any written language contradicting it, the courts are going to assume that that easement is granted into eternity, right? It's a permanent easement, unless the terms specify otherwise. It's also important to know that if there are ambiguous or vague terms in the agreement, the court's going to interpret those to benefit the easement holder, meaning the person who has the right to use the easement, not the property owner. The second way you can create an express easement by agreement is through reservation, meaning if Susan decides to sell her property, but she really likes to use the lake on the property for fishing, she can sell her property and reserve an easement for herself to continue using the lake and the property for fishing purposes. That's an easement created by reservation when you sell the property. And when you're creating an easement by reservation, traditionally the courts have said you can only create it for yourself. You can't benefit someone else. But more modern decisions are telling us actually that you can reserve an easement in favor of a third party. It might be the public, it might be your neighbor, it might be someone else who's going to benefit from that easement. So we just talked about creating an easement with an express writing, right? That's probably the most common way that you're going to see an easement created. It's the way that you think about most often when you're approached by someone like an electric utility or a natural gas company about access to your property. They're going to want an express agreement. The other way that an easement can be created, though, is by implication. And what I mean by that is by circumstances or activities or history that has occurred which implies that an easement exists. And there's kind of two ways that happens. The first is by necessity. And this happens when a property is subdivided and suddenly you have a landlocked parcel without any access to a public road. The courts are going to look at that if there's a dispute, and they're going to say, actually, the intention of the grantor couldn't have possibly been to just landlock this property. They must have granted an easement. So we're going to assume by necessity that easement exists. The second way that an easement can be created by implication or by acts is through prescription. This is kind of similar to adverse possession, and it requires a continuous, notorious, and adverse use for 21 years or more. This is an interesting situation. It makes you think, how do I keep an eye out for this? How do I know if this is happening? And we're going to talk a little bit about that. But an easement by prescription is something that can be stopped by your acknowledging that it's occurring, your prohibition of anyone accessing the property and using that for greater than 21 years. And there's other ways that we can talk about as well. But I also wanted to mention that an easement by prescription can be also established in Pennsylvania on behalf of the public. And we're working on an interesting case right now in Clarion County where we've alleged a public prescriptive easement for a hiking trail that's been used for the last 50 years. And it crosses some private property, and we're thinking through, what does that mean in terms of long-term rights to use that property by the public. So it'll be an interesting decision. But if you're a property owner and you're thinking, well, I have 100 acres, there's no way I can possibly police the entire thing. I want you to know that in 1850, the Pennsylvania legislature was thinking about you, and they enacted what was known as the Unenclosed Woodlands Act. This is a defense to prescriptive easements, and it essentially says that if you're a property owner who owns woodlands, and those woodlands are not enclosed by a fence, and you don't notice that, for example, the neighbors have been walking across your property for the last 21 years. It's possible. We're not going to establish a prescriptive easement there because we want to keep those properties protected. We want to keep those woodlands in place. And for something like 170 years, the Pennsylvania courts never really told us what they meant by a woodlands, right? There was all of these cases where it was clearly woodlands or it was clearly not woodlands. And it was only in 2018 that the courts took this up and tried to decide what the legislature meant in 1850 by woodlands. And in this Williams v. Taylor case, there's a I'm going to call it a wooded area. I don't know if that's a woodlands, but a wooded area next to a stream, right? And there was a dispute about whether a prescriptive easement had been established on that property. And the parties, they brought in two experts, right? Williams, he brings in sort of a forester, an ecologist, who comes and talks about the riparian benefits of the wooded area, talks about the forest management plan that he put in place, talks about all of the ecology, the different trees and shrubs that are there, and says, to me, that looks like a woodlands. On the other hand, Taylor comes in and says, well, I'm a sawmill owner. I sell timber regularly. I know a lot about these things, and when I walked over there, I don't see a single tree that I would want to cut down for commercial purposes. So the court's faced with this, this decision to make. Is an unenclosed woodlands sort of the ecological definition that we think of when we think about woodlands, or does it have some sort of commercial definition? And the courts, as you see in this quote here, in 2018, they adopted the ecological definition, which is probably much broader and which is probably better for a lot more property owners when you're thinking about protecting your property from unenclosed woodlands. And the courts explicitly there said we're not only protecting commercial woodlands, but we're protecting these properties for conservation, for recreation, and for other purposes. So that makes me, start to think about conservation easements, which are a little bit different than the easements that we've been talking about in terms of right-of-way or access. Conservation easements are really, sometimes they're described as an easement on, or an easement for development rights. So you can think about it as handing over the stick that allows you to develop your property. And typically you're handing it over to a nonprofit like a land trust, or to a government agency like through the Agricultural Conservation Purchase Program. And you'll note that that's an easement in gross created by express grant. And if you're thinking, how do I know if there's an easement on my property? You now know that there's only two ways to create an easement, either by express creation, meaning you need to check the county recorder of deeds office, and you could consider hiring a title agent to do a title search for you, or you could kind of do that yourself depending on the purposes and the kind of needs you have. Or they're created by implication, right, through either necessity or prescription. And that means you can monitor your property, you can evaluate what's happening, and you're going to become aware of whether there's an easement there. And if you have an existing easement, it's typically a written easement. You're going to want to think about ways to maintain those documents so you don't have to go to the county recorder of deeds every time you want to take a look at it. I typically advise folks to periodically review those because there's going to be sometimes there's terms that change over time. So there might be time limits, there might be other types of actions that have occurred that affect the easement. Like I said, you're going to want to kind of keep an eye on your property, know whether that easement's being used or abused. You're going to want to incorporate the scope of that easement into your long-term planning for your property. Kind of like we mentioned, a lot of times those are permanent easements. Depending on what type of easement it is, it may or may not transfer with property ownership, so you're going to think about how that planning plays into it. And if there are issues, problems that arise, you may want to think about enforcement of the easement terms or defense, depending on kind of what side you're coming at this from, whether you're the easement holder or the easement grantor. Typically, if it's an express easement, it was created by a written agreement, and that means you have a breach of contract. Whereas if it was an easement created by implication, it's probably going to be an action in trespass or ejectment, something like that. And those are all filed initially in front of the County Court of Common Pleas. When you're talking about new easements, though, so you've been approached by a land agent or a representative of a utility company or someone, maybe PennDOT, someone else, you're going to want to understand your negotiation power, first of all. It's probably one of the first things that you're going to want to think through is whether eminent domain is at play. And we're going to talk a little bit about that in a couple slides. So other than that, though, you're thinking about, most people are thinking about maximizing financial benefits while also maintaining the long-term goals and plans that they have for their property. And you're going to want to be specific, because when it comes to any dispute, the language of that agreement controls. It doesn't matter what so-and-so told you on the phone or by email. The language of that agreement is most important. And once you've adopted a new easement, or if you're thinking through, what types of terms and provisions do you want to put in your easement agreement, you might want to think about some best management practices for both the easement holder and you as a property owner. And when we're talking about electric utilities in particular, this is just sort of one example that we pulled from another website where they talk through the different areas of clearance that are required for transmission lines versus distribution lines, how that affects the vegetation on your property. As an electric utility, they're thinking about maintaining service and meeting the sort of federal clearance requirements. But as a property owner, you're thinking, well, who's obligated to maintain this? What can I do or what can't I do in that easement area? And those terms can all be specified within your easement agreement, often with an understanding of kind of what that electric utility has to do or what they have to maintain for safe and reliable service and maintaining compliance with the regulations that apply to them. So if you are approached by an electric utility or an agency like PennDOT who wants to put a road in, eminent domain is often something that might come up in that initial conversation, or it might come up later, but it should be something you're thinking about. And very broadly speaking, eminent domain's really just about the power of the government to take private property for public use. But you'll note in this definition that it's not really just the government. It's state government, it's local government, it's public utilities, it's private entities if they've been authorized to use eminent domain authority, and it's electric cooperatives. So it could be a broad array of people. But if we're talking about the power of electric utilities in particular, one thing to keep in mind is that before any electric utility approaches you to negotiate or to even discuss selling your property or obtaining an easement, they have to give you notice. And they're going to send you a certified letter by mail, and it's going to tell you that they're going to describe the project that they're interested in, why they need a right-of-way across your property, what the general scope of that right-of-way is, and what some of your rights are in terms of responding to them. So once you get that letter, you should know that they're doing that because they're legally required to give you 15 days notice. That's usually a good time to consult an attorney if you're interested in doing that. And it gives you an opportunity to think through what's being proposed and how it affects the plans for your property. I should note that if you've refused to deal with them in terms of negotiating an easement, or if they, for whatever reason, have decided to pass over that step, what they're going to do is they're going to initiate condemnation against the property, or they're going to start to exercise their power of eminent domain. And typically the first step in that is filing for a certificate of public necessity with the Public Utility Commission. And you should know that there is a hearing process involved with that. So if you're the property owner whose property is being exercised against, you should know that there's an opportunity for you to participate in that process to challenge that public necessity. After a certificate of public necessity has been granted by the Utility Commission, that's not the last step. The condemning party then has to go to the county court and file a declaration of taking. But even before they do that, you should know that that party does have a right to enter your property. But they have to give you notice before they do that, and they're only allowed to enter your property for a limited purposes of conducting appraisals or studies to know what's going to be required. If it comes to a declaration of taking, as I mentioned, that's going to be filed after the hearing in front of the Public Utility Commission, and it's going to be filed in the county court and also at the county recorder of deeds. And you're going to get most likely another certified mail notice of that filing. And you're going to have 30 days to respond to that filing. You have to respond with preliminary objections. And if you do not respond within that 30 days, they have the right automatically to make an offer, to make a payment, and to take possession of their right-of-way. And a lot of times when property owners who don't want to negotiate or don't want to give up rights to their property are faced with the prospect of eminent domain, a lot of times we think, well, let's put a conservation easement on it, right? I told you a couple minutes ago that that's the rights that you give up for development. What's interesting is in Pennsylvania, that conservation easement will not stop eminent domain. And in fact, I worked with several property owners north of Pittsburgh a few years ago who were faced with eminent domain challenge from a sewage authority that wanted to put a sewage wastewater plant on their property. They didn't like that, and I had to tell them, putting a conservation easement on it's not going to stop it. So what we did is we put a restrictive covenant on the property, and then we hired an engineer that helped us challenge the analysis that they were doing for the sewage treatment plant, and it turns out they ended up choosing a different property. So we got lucky in that case, but it wasn't placing a conservation easement on it. That analysis, though, and that strategy changes a little bit after June of 2018 because organizations like the Pennsylvania Land Trust Association and other groups lobbied hard for Act 45, which essentially prohibited taking of a property under conservation without first going to the orphans court and getting approval. And when the condemning party goes to orphans court, they need to make a demonstration that there's no reasonable and prudent alternative. So since 2018, there really haven't been any cases that have told us definitively what this means, reasonable and prudent alternative. That's something we're going to keep an eye on and we're going to be watching and we're going to learn more about. But you should know that now, after 2018, there is sort of another procedural step if there's a conservation easement on your property. But you should know that there are exceptions to that. Certain common state agencies don't have to comply with this, and it doesn't apply in emergency situations. So the other issue that often comes up when we think about eminent domains is often natural gas pipelines. And frankly, oftentimes a pipeline or a lease agreement can be life-changing for a property owner. Sometimes in a really negative way, but sometimes in a very positive way. It can give you financial benefits that help you maintain your property over the long term, that help you manage your property into the future, but it can also create problems. But you should know that certain pipeline companies, depending on how they're regulated and depending on the type of pipeline that's being built, may have eminent domain power. So in 2017, this was tested in front of the Commonwealth Court related to the Mariner East 2 pipeline. You've probably heard about this in the news out east. Sunoco came in and they filed a declaration of taking against this private property owner for a small permanent easement and a slightly larger temporary sort of construction staging easement. And the property owner challenged that declaration, saying, "Hey, you're not the state. You're not an agency of the state. You don't have the right to take my property by eminent domain." The Commonwealth Court, though, they ultimately found that Sunoco was regulated as a utility by the Public Utility Commission, and they were authorized to exercise that eminent domain authority by the Business Corporation Law. Further, the property owners were challenging the public necessity of the project, saying, this doesn't meet your certificate of public necessity standard. This is purely for private interests. But the court sort of ruled on a procedural issue and said, even if that were the case, you're making that challenge too late. You should have made that challenge in front of the PUC, but you're bringing it up now in front of the trial court. Interesting result, but something to keep in mind if you're negotiating with any of these companies is that depending on the type of project, depending on how they're regulated, they may or may not have eminent domain authority. A totally different scenario, right? When eminent domain happens sort of by implication. They talk about this as a de facto condemnation. And the DeLuca case, which was decided in 2017, is a good example of this. In that case, the DeLucas, they owned property next to a sewage treatment plant. And that plant, due to capacity issues, due to technical malfunctions, was discharging a significant amount of raw sewage onto the DeLucas property. It was, from what I've read about, is pretty terrible. And they had to leave the property for a period of time. They turned around and they said, hey, you're the sewage authority. You're an agency that's authorized by the law to exercise eminent domain. You've effectively prohibited me from utilizing my property in the way that I otherwise would. This is a de facto condemnation. This is you exercising eminent domain without saying it, right? And the Commonwealth Court, they agreed, and they awarded damages caused by the repeat overflows and the value of that use, saying this, in fact, is de facto condemnation. It's effectively the government using their eminent domain power because they didn't have any other option to dealing with these overflow problems. So that's all I have to say about eminent domain. So we've talked about how you create easements, how you monitor existing easements, how you negotiate new easements. The next question you might have is, well, what if I don't want the easement anymore? What do I do? How is it terminated? And there's essentially 5 ways that you can terminate an easement. The first is just by the limits of its creation. And that means in that written agreement, you're going to say this easement only lasts for a certain number of years, or it only lasts until X happens. The second way is by unilateral action of the easement holder. That means if I'm the person that has the right to this easement, to use this easement, if I decide that I don't want to use it anymore, I can file a declaration of that, of termination with the county recorder of deeds, and I can essentially deed the easement back to the property owner. The third way that an easement can be terminated is by mutual agreement. And this sort of makes sense, right? The 2 parties get together, they say, I don't want the easement anymore, I don't want you to have it anymore. Let's both execute an agreement that, again, is filed with the county recorder of deeds and deeds that easement back to the property owner. The fourth way that an easement can be created is by the doctrine of merger. And essentially what this is where the easement holder and the property owner, through some transfer of property, are the same person. So, for example, if I had an easement across my neighbor's property and my neighbor decided to sell his property and I purchased that property and then I combine our lots, I suddenly hold an easement to cross my own property, which doesn't make sense, right? So the courts say we're going to allow that to terminate an easement. There are exceptions to that where they would keep that open for purposes that would benefit like some third party, for example. But generally, the doctrine of merger will terminate an easement. And then finally, the last way is through abandonment. And this seems simple, right? If someone's not using the easement, they abandon it, it's over. It's terminated. Yes and no. So abandonment is very difficult to establish. You essentially have to show that there has been absolutely no use of the easement and that use has almost become impossible. There's a number of cases that talk through exactly what that means and what's required, but it's often a very factual analysis depending on what's happened in each scenario. So those are essentially the 5 ways that you can terminate an easement. And I just wanted to end by talking about taking this information. Hopefully you've learned something new. I'm sure a lot of you have had some of this knowledge already, but hopefully you can take some of this information about easements, about right-of-ways, and think through what it means for your property, how you're going to either continue monitoring existing easements or how you're going to think through approaching new easements or right-of-ways, taking steps to manage the future of your property in a way that makes sense for you. So that's all I have. And then I will stick around and answer any questions if anyone has them. So, thank you.